an opening statement, and a rebuttal not to exceed 5 minutes. Okay, with that in mind, let's pull the first case, which is at Laura's Learning Center.
Good morning, may it please the court. My name is Jean Penny and I represent Laura's Learning Enrichment Center. I would like to reserve 5 minutes for a rebuttal.
All right.
The Learning Center is solely owned and operated by Laura Smith and it's been a licensed daycare center since 2009. The Learning Center is respectfully requesting that this court reverse the final order entered by Department Secretary Harris, which denied the Learning Center a license, and remand for entry of the amended final order that Secretary Harris also signed, which granted a license to operate the daycare center. I sincerely hope that makes sense to this court.
Well, we'll cut to the chase. What did the secretary do wrong that the secretary was not authorized to do?
When she did the first final order or the amended final?
Well, the amended. They changed everything, right?
Yes, that's right. That the amended final order is perfectly correct. The problem is that the parties asked this court to relinquish jurisdiction for entry of the amended final order. This court denied that request. And then this court invited the department to concede error as an alternative. The department refused to do that. And so the briefing process began. Now, in the answer brief, the department completely did an about face, is defending the final order, basically saying, please ignore the amended final order that was entered. And that's why we're here.
Okay.
So the facts of the case aren't really in dispute. Basically, what happened was at the time.
The facts in the case really aren't in dispute. This is your argument that the department is disputing facts, that the factual finding of the ALJ though?
No, the department, so what happens that the department actually did dispute the facts initially. And so Laura's Learning Center requested an administrative hearing. It went to an administrative law judge. They filed the pre-trial stipulations. In the pre-trial stipulations, the party said there's one fact that we want you to decide.
So to cut to the chase, and you can again correct me if I'm wrong. In other words, your perception of the department's position that even if the incident that at first ostensibly was what the ALJ was supposed to adjudicate factually, did not happen, that the department was still correct in, as a legal matter, denying the license based on, I guess, the report, the incident. Is that correct?
Oh, I'm sorry, I apologize, I don't understand.
Okay, so the incident,
Yes,
my understanding is the ALJ made a factual determination that the incident did not take place.
yes, that's correct.
Right, and you're saying that the department's position now is, even if we accept that as true,
Mhm.
we're still correct in denying the license.
Well, that's the first final order.
Mhm.
So the first final order says, we are correct in that regard because there was an abuse report that was a child abuse report.
Even if the underlying incident never happened.
Right, we still can deny her license. The problem for the department was that they did renew the license. So after the administrative law judge entered the recommended order, making a factual finding that the incident did not happen, the department renewed her license in May of 2021. After the license had been renewed for 3 months, the department entered the final order, which says the license is denied. So at that point, everybody realized there was a problem. We, of course, had to file the notice of appeal, even though she had a license. Now we've got this finding that apparently she shouldn't have the license. So the appellate record is silent, but from August to December, the next thing that this court knows happens in December, there is the amended final order that is entered that corrects the final order and adopts the recommendations of the administrative law judge. That's when, and in that motion that's filed to relinquish jurisdiction, the parties represent, the appellant represents with an unopposed motion that this amended final order moots the substantive issues on appeal. Unfortunately, the motion was denied, so now the problem still existed. Now we still have a problem. She's still operating under her license, which she did until just recently, when she went to renew that license she already had, and the department denied her renewal, not based on any new wrongdoing or any new allegations, but solely because this appeal is pending with the final order still in place. Even though the amended order has already been entered by the secretary, they denied her renewal license, which led to a motion for stay, and which led to a response saying basically the only reason they entered the amended final order was to correct the mistake of entering the license back in May of 2021.
They didn't want to renew the license, so they wanted to correct that. It wasn't renewed on an interim basis pending the appeal or pending a final order. That was the final order.
Right, it was a one-year renewal. So
Every year it's a one-year renewal, right?
right, so that's what they gave her in May of 2021, a one-year renewal that lasted until 2022. So this case is long since ceased about being protecting children in a daycare center from somebody lacking good moral character. In fact, I'm really not even sure what this case is about anymore, because the department entered an amended final order that corrected the problems with the final order.
You corrected the problem from their perspective, but not from yours.
No, it perfectly corrected the problem from our
So
perspective.
you were both happy.
We were both happy, but the court wasn't happy.
Well,
This
it
court.
sounds
This
like
court
there's a
wasn't.
misunderstanding, but in other words, are both sides ready to fix this case today without judicial intervention? If we do something with this previous order that sounds like it should have been granted? Is that what I'm hearing? At some point, tell me the answer. You don't have to tell me now, but both sides address that. Because maybe, using common sense, you got a different panel, maybe we can reverse throttle on the order that you said should have been granted, and you would have fixed it.
Right, well, I'll tell you the problem from our part. What we have in place is a final order that says my client, Ms. Smith, lacks good moral character.
That was the reason for not renewing the license.
No, well, no, because technically her license had already been renewed, but the administrative law judge said that that wasn't true. She did have good moral character. They renewed her license. Now final orders entered saying she lacks good moral character, which means that she can never work, she can't own her daycare center anymore, and she can't work in her any
So
daycare
you
center.
need to get rid of that finding. You need
Yes,
to have an amended order deleting that and giving her the license.
which is what we have, but
Okay,
but
but you don't know if the department in view.
That's not the correct, sorry, Judge.
No, that's all right. I just want to find out, is there an easy way out of this thing where everybody's happy?
well, we thought the easy way out of this, where everybody was happy, is if the court just relinquished jurisdiction for entry. of
And that was
the final order.
denied.
That was
So
denied.
my question is, that's not etched in stone. If we made a mistake and should have released jurisdiction, I always release jurisdiction to get the case resolved between the parties. So somehow, somebody, a three-judge panel decided not to relinquish jurisdiction. Why, I don't know. I mean, the case is fully briefed as if it's hotly contested, but you're saying it really isn't. So which is it?
Well, we hotly contested the final order. We agreed with the amended final order, so And I can go through why we believed, I mean, and it's in my brief, why we believe that the final order was incorrect, why, you know.
Okay,
why-
let's do this. This is highly unusual.
Yeah.
Let me call the second case. You guys have a powwow outside. Come back and I'll call the case again. Can we do that, or am I making you do a futile thing?
The problem is this court questioned the jurisdiction for the department to enter the amended final order if they didn't concede error. So
So it's something that they probably don't like to do that.
Judge Valenti.
Yes.
Maybe the case that, I mean, my understanding, and I may have a misunderstanding, was that the department is prepared to argue that the finding of lack of good moral character, or at least the denial of the, or at least the denial of the license was correct.
Okay, so
Is that-
I don't want you to do a futile thing. Let's just proceed then. See what the department says.
okay,
Let me ask a question.
Sure.
The final order that was entered, is that the basis for the denial of the renewal of the license the following year?
yes, that was the basis for the denial of the 2022 license.
The 2022.
Yes.
Okay.
Yes, and so that is the order that we need to get corrected, or doctrines of finality will attach to it, and then she won't ever be able to work in daycare center. So that, one of the issues with the final order is because, as Judge Atkinson mentioned, that the secretary said the administrative law judge was incorrect in its finding that she could have this abuse registry in existence, but we can still look at the underlying facts. And if we look at the underlying facts and find that that incident didn't happen, then I still can find good moral character. Secretary Harris said, no, that's not correct. The fact that she is present on that child abuse registry means that she is automatically disqualified from having good moral character, which means she's automatically disqualified from a license renewal. So that's our first argument, is that is an
Well,
incorrect.
that sounds like an administrative inconsistency. Does this court have power to fix that? That's my first question. I mean, as a division of labor, you have the administrative executive function. I don't see how the courts can tell the executive what to do, even if it makes no sense. I don't know if we have the jurisdiction to do that. That's something I just realized.
Right, well, the administrative law judge actually goes through all of the statutes very carefully. And the administrative law judge properly looked at the statutes and applied them. And Secretary Harris also looked at the statutes and incorrectly applied them.
So we could be over here on a few, your theory could be one of the, under 120.57, a few different grounds for action that you're requesting from the appellate court, right? Judicial review of an agency determination. So one is, and I do need to hopefully get it straight here. Unfortunately, the division of argument means that you have to characterize the appellee's argument before the appellee gets to get up there and characterize its own argument. So there was, let me characterize it thusly. So if going back to what I was postulating might be the agency's position, which is that at one juncture was, even if the incident, even if they accept, they can do one of two things. They can say that the company's substantial evidence was not to support the ALJ's findings, and they can reject them, or they can say, our interpretation of law is superior and as or better, right? And they can reject it, correct, under 120.57. So in other words, if they let stand the ALJ's finding that this factual incident, not this factual incident didn't happen, then their fallback argument or their other argument was, well, even if that incident didn't happen, she appears on this remind me what the report's called, the
Child abuse
child abuse
registry.
report,
Mhm,
and
yeah.
that is ipso facto pursuant to the statute, something that prohibits us from issuing a license, right? So is that one of their, at one point, one of their arguments that, in other words, and you're saying that the department's reading of all these statutes, including the one that they're saying gave rise to a duty to reject the license based on the fact that she appears on this child abuse list, is not as or better interpretation of the 120.57 in the AOJ, but it is worse. It's wrong.
Right, it was wrong, yes.
Right, so but then there also a separate argument, which is to say that they could reject the finding, and have they ever made this argument, and if so, what would be your counter argument, that they can reject the finding, the factual finding made by the ALJ, because that ALJ imposed an improper level of proof. In other words,
Yeah.
clear and convincing as opposed to compliance with evidence. If that was their route, could they say, you know what, we decided did happen, or there's credibility to it, that by the preponderance of evidence, the incident did happen, and we could just reject the finding because the ALJ did not apply the correct standard proof.
Well, the secretary did do both of those things. It was just she reinterpreted the statute and said it's ipso facto, like you said, if you appear on this registry, it doesn't matter if it's true or not, the underlying facts, then you're disqualified. She also said that she did not agree with the factual findings that the administrative law judge made. She believed that he didn't give enough credence to some of the facts that were made, and she believed that, you know, they demonstrated a lack of good moral character. Coming to the
Let's say
burden
for
of
the sake of
proof, yeah.
discussion that I'm not gonna speak for my colleagues, but I deem that to be an improper rejection of administrative law judge's factual findings, what you just described.
Right.
And I don't know, from your perspective, what is the answer to my question regarding
The burden.
an alternative basis for rejecting it, which is the misapplication by the AOJ of the proper standard, evidentiary standard. Would that be an independent basis? In other words, they did, without reweighing, in other words, they said we can reweigh the evidence, or we're not even reweighing the evidence, we're just saying it did happen because we get to reject that finding because the AOJ applied the wrong standard of evidentiary support.
Well, the secretary can't substitute their judgment and review the evidence and weigh the credibility.
What would happen though, what is the recourse for an agency if they send it to the AOJ, they send it back?
Well, that's what they asked to be done
They
in
send it
their
back to the
conclusion,
new LJ for
Yeah.
another evidentiary?
to redo it. They said at the most, we would like it to be sent back to, and I can't quote the conclusion right now, but for the ALJ to reconsider the fact, make factual findings based on a preponderance of evidence standard rather than substantial, clear and convincing.
Yeah.
Now, I don't think the court has to reach that. We can argue clear and convincing because what the nature of this, it is penal in nature.
What do you have to support that? And isn't this statutory? I mean, that it's a preponderance of evidence? What do you have
Well,
to
the
support
statute-
the clear and convincing, that a
Well,
clear and convincing
yeah.
preponderance?
12057(1)J, it's preponderance of the evidence unless it's penal or disciplinary, licensed disciplinary proceedings.
Wait, where,
So-
which subsection? I know. I
Oh,
saw the
I'm
brief,
sorry.
but-
1J, 12057(1)J.
And then so after the word unless, it says unless it's statutory, you don't have a statute that says it's clear and convincing, right?
No.
You're saying this is penal.
Yes, because we know it's penal because in 2022, she didn't get her license renewed only because of this existence, and she will never.
But let me ask you this, so from my, you say in the briefs, you're saying now it's penal, but in the same sentence, you're saying a license non-renewable. How's that penal?
Because it renews
It's
her.
regulatory, right? You do or don't get a license.
Well, so in the Davis case, it talks about you have to look at the nature of the action and the underlying rights implicated that governs that applicable evidentiary standard. So I do understand that this law is very confusing, at least in my mind, right now, regarding license renewals.
What happened in Davis?
In Davis, there were two. There was a renewal for an existing license, and then there was an application for initial license to expand to a large daycare. The second district applied the clear and convincing evidence standard. The Supreme Court said the clear and convincing evidence standard did not apply to an initial application. But the
Denial of a renewal, they said the clear and convincing applied to.
they didn't specifically state that because that wasn't one of the issues that was brought up to the Florida Supreme Court. But they didn't say that that was improper for the second DCA to have done that on the renewal, because that was disciplinary in nature. I mean, I don't wanna quote them, they just didn't say it, because it wasn't before them.
Ms. Sen, I don't want to interrupt you, but you've gone through the 20 minutes plus.
Oh.
So that's okay. What I want to say, because that's not really your fault, I'll give you the 5 minutes rebuttal if you want to stop now. If you feel like you've got to get some more stuff out, I'll take it off the 5 minutes. Want to save it for rebuttal?
Yes.
Okay, let's move on. Okay, your turn.
Thank you. Good morning, Your Honors. Judge Atkinson, Judge Mendy, Judge Smith. My name is Shane DeBoard. I represent the Department of Children and Families. It's a pleasure to be here with you this morning. In this particular case, first, I'd like to address, let me grab my notes, I apologize. I'd like to address the amended final order. I was a little bit surprised to see that mentioned in the reply brief. That particular document was something that was a settlement, I guess, opportunity invited by counsel for appellant. So to see that and to see that being argued as part of the record here today, to me is really inappropriate. It shouldn't happen.
Well, they offered to take a recess, let you guys
I
flesh it out, but it didn't seem like that was going to go that way. But let's try and get past that. I feel probably responsible for talking about something that maybe I shouldn't have.
oh, no, Judge, no, thank you. I'll move forward. Judge Atkinson, as you pointed out, this is not a disciplinary proceeding. There was an existing license at the time this incident happened.
Well, I was just raising the question, you could address Davis, which.
Well, I'd like to address the statute if we can start. I think it's always important to start with the underlying statute, chapter 402. And in chapter 402, let me find it in my notes. Oh, here we go. 402.308, issuance of license, subsection 1, says it's renewed annually. You jump down to subsection 3B. Says a license can be renewed only if the department determines if minimum standards for licensing continue to be met. One of those minimum standards is that the owners, operators, they have to be able to pass a background screening, right? You have to be a good moral character. If you walk through 402.302, 402.305, 402.308, and 402.3055, all of those statutes discuss background screening and good moral character, how important that is for the care of children. So in this particular case, the department did not reject any finding of facts. I took the order, the recommended order, and I took the final order. I put them side by side. I read through them. I can march you through my notes if you like. In paragraph 3 of the finding of facts in the ALJ's recommended order, he makes a clear finding. There's a verified abuse report. Then he goes on for several other pages talking about the
Because the
facts.
finding is that there's a report. No, no, it's okay, you don't, you're not saying, you're saying the finding, I'm just asking you, are you saying that's a factual finding in and of itself?
That is a factual finding.
So that supports denial because ipso facto, if you're on a report, you have bad moral character and therefore the license cannot be renewed.
402.308 3D says a license may not be issued or renewed if any of the child care personnel at the applicant facility have failed a screening as required by 402.305 and 402.3055. That's what the statute says.
Okay, so what in 402.305 says, what section says that if you show up on a list, you have bad moral character?
Well, it says if the department's made a determination that you lack bad moral character, then a license can't be renewed.
Okay,
That was what
was the
Is that a factual finding? Is that
That
supposed
there's
to
a
be?
verified abuse report?
Well, no, good moral character. Doesn't that entail, I mean, in the statute, it talks about screening, and if the department finds that they failed the screening required, and screening, I think, is defined further in one of the statutes as assessing. So isn't there some sort of review or assessment that has to go into play, as opposed to just simply that there's a report of a verified abuse? I guess I'm concerned that your application of the statute and the secretary's application of the statute is constrained reading of the statute.
I understand your point, and I think if you go back in the record, if you look at the denial document itself, right, the denial of your renewal application, the department lists out the reasons or, the issues it had, with this particular applicant at that time, and it denied the license. I understand that the ALJ made a determination, and the department didn't disturb that, we find the credibility of these 3 witnesses greater than the credibility of the child, and found that Ms. Smith, really wasn't involved in the incident.
So why do you need an ALJ to make a finding that there's been a verified abuse report?
Well,
Why did you send it to the ALJ? What was the dispute of fact?
I'd have to go back and look at the,
What?
I
I don't
apologize.
remember why.
Well, no, I mean, one of the.
Why did the agency send it to me?
One of the disputed facts, which was in the stipulation, and it was just simply one fact that was in dispute, I think, in this case, was whether Ms. Smith was there when this occurred, correct? And that was in the stipulation in this case.
So why does that matter at all if there's a verified abuse report, you can't renew the license?
That's-
Why would you have an ALJ to determine that factual matter?
Well, you
It
need
doesn't matter at
to,
all.
if you have a disputed fact, then it has to go to the Division of Administration.
No, dispute of material fact.
It's dispute of-
Material. Why is it material if the mere existence of the verified abuse report means, as a matter of law, deprives the agency even the authority to grant the renewal?
Well, that's what the statute says. If the agency makes a determination that the continuing standards for licensure isn't met, then it shouldn't be renewed. And that is one of the.
I don't know if you answered my question. Why send it, in order to, your agency it's your agency's decision. Denial of a hearing, evidence hearing could be, appealed, right? But at that time, it was your agency's decision to say, yes, there is a factual dispute. Your agency, I'm sure, is not in the business of sending immaterial factual disputes to ALJs, right? No. So what was the material fact that the ALJ was supposed to determine, that needed to be determined in order for the agency to make a determination whether to renew the license?
The circumstances surrounding the events that occurred in this case.
Right, so
The denial.
would you agree the ALJ said that it did not happen?
He found that it didn't rise to clear and convincing evidence. Like,
Right,
if you
it
look at
didn't
the,
happen, but no matter what standard of proof, that's just standard proof.
if you,
Beyond reasonable doubt, he said it didn't happen. That's a separate issue. I don't want to talk about the standard. I want to know, do you agree or disagree that the ALJ found that it didn't happen under whatever maybe erroneous standard of proof he employed?
well, I think you have to, if a finding like that, you have to couple in with the burden of proof that was.
No,
finding
okay,
correctly in this case.
under a clear and convincing standard, did he find that the incident did not happen?
That is correct, but that was the wrong one.
Okay, so
wrong one to
in
apply.
other words, I'm trying to parse our argument. We have to parse our arguments. You can't obfuscate and mix them up and muddle them up and have us just decide the case that way. We have to delineate them. One of them is, my understanding you correctly, is even, let's say, for sake of discussion, that the ALJ imposed the proper burden, right? And under the proper burden found that there was not a preponderance of evidence to believe the incident happened. My understanding of the argument is that the license would still have been justifiably denied based merely on the fact that there was a report. Is that right? Right, yes or no? Yes or no?
I don't think I can say yes or no to that question. I mean, you'd have to litigate the.
So
the
you
case
don't
under
want
the-
to parse out the arguments enough for us to make our decision then? Because what do you want to make us to make our decision on? What argument? The argument that even if the underlying incident was found by an ALJ under the hypothetically, the correct burden of proof not to have happened, that the agency was still correct in denying the license based on merely the fact of a report? Yes or no?
I think the agency can based upon the way the statute reads.
Okay,
However,
so that's one of your arguments.
there was a lot of other,
That just the report means that the license should be denied. So the second argument that you were trying to shunt me towards was the factual finding could be rejected, is that right? Because it was made under the wrong standard of proof?
there was no rejection of factual findings in this case. And, you know, if you look at the statement of the issue in the recommended order, it says denial of a renewal of an application. And then you go through the rest of it, and then it talks about a disciplinary procedure that applies the incorrect burden of proof. There's really no legal analysis, you know, in the recommended order other than citing to one of the ALJ's own DOA cases. And when you have a case that's kind of messed up from soup to nuts, I think, in the recommended order, and then you try to fix that in the final order, which I think it did, you know, you apply the statute, here's the statute, there's really little to no statute.
I'm just trying to ask you how you fixed it. Did you fix it by saying the secretary is a human being who's appointed by the chief executive of the state? Did she fix it by deciding that the incident happened? Or did she fix it by deciding that, legally speaking, even if it didn't happen, that she couldn't renew the license because of a report? I'm just asking you what she did. You're telling me that she fixed it in the final order, and how did she do it?
The final order applies the facts as found by the ALJ that there's a verified abuse report against Ms.
Okay, so you're saying the secretary said it doesn't even matter whether it really happened.
No, I was, in other words, the second part of my point was the ALJ applied the incorrect burden of proof, treated this as a disciplinary matter when it's not. You have a current instrument, which is the, you know, existing license, and then you have the second instrument, which is the application for renewal. And the legislature tells us in the chapter, you have to really go through and make sure everybody has the ability to be renewed based upon, do they still meet the minimum standards for licensure? In this particular case, it wasn't. It was also tied up with her revocation of her foster home license, which she didn't contest, and there was a new application that she submitted and was incorrect. The ALJ didn't really find on that, but that's, you know, that is, you know, it was just part and parcel of all the information that was there.
Let me ask you a question. So she has a license for a period of time. During that period of time that she had the license, I think this is 2021, if I'm correct, then there's no action taken by them. There's no action to revoke that license. And the only action taken is when she seeks a renewal of that license.
Are you talking about in 2022, Judge?
Yes.
Okay, right, well, I'll just point that is not part of the record either. You know.
But, okay, so our record, the record that we have before us, which is the only thing I want you to talk about, is that there's nothing between the time she's operating until the denial of the renewal. Do I have that right?
One more time, I
As far
apologize.
as it's action to take away her license. There's no proceeding to revoke the license based upon the verified child abuse registry, right? There's the only
Correct.
time the only time this comes into play is when she seeks a renewal.
Correct. The initial license, the license that was inadvertently given to her at the local level was out of touch with what happened to Tallahassee. And I can just tell you that is, I mean, we're speaking a lot off the record in this case, which is, you know, it's kind of odd, but that is what it is.
But that wasn't my question to you, was to make sure that we stay on the record.
Okay,
Okay. So our record is that the only time that there's some denial of any sort of licensure is when she seeks to renew the license she's been operating under, correct?
that is correct.
Okay.
Yes, which got us to where we're at today.
So Councilor Appellant mentioned when I brought up the issue of whether an agency is permitted to reject a finding of fact if an ALJ has, in the estimation, or has let's just presume for the sake of discussion that the finding of fact was made by application of the wrong evidentiary standard. Doesn't an agency have the authority under 120.57 or wherever to reject that finding of fact?
Reject the finding of fact based upon an inappropriate application of a burden of proof? Is that your
Yes.
question?
Yes.
I don't know the answer to that off the top of my
So
head.
what should happen? What's the agency's, in other words? I mean, at this point, we've argued for 40 minutes and I still don't even know whether the agency, the agency had made a determination, relied on the finding or not.
The finding of fact?
I want to know if the agency had relied on the finding that the incident didn't happen.
The agency made a determination in its final order based upon paragraph 3 of the finding of facts of the ALJ's recommended order that Ms. Smith had a verified abuse report.
Right, so
And
so
then-
you're saying that, so let's say for the sake of discussion that we disagree with your agency head on the law. That we disagree that a verified incident report, whatever, I keep messing up the terminology.
Abuse report, Judge.
Abuse report on the registry. That as a matter of law justifies the denial of the renewal. Let's say that's how we decide. So then it does matter whether the ALJ's finding of fact is accepted or not, right? Because it does matter whether the actual physical incident happened. Am I correct? In other words, we have to peer beyond, well, I just said it. just-
Yes, right, I understand what you're saying. Here beyond the report and what is the litigation paragraph? That's your.
Yeah, so if we reject your argument that the report alone justifies the denial of renewal, what say you about the finding that it didn't happen?
Well, yeah, I guess that's the position my agency's in all the time. You have tough cases, children, and they're always outspoken by older adults, and it's very hard. That's our mission. But
No, the 120.57 was passed by the legislature, and so you have to follow it, and your agency has to follow it, and what is she gonna do? Is she gonna just say, yeah, you know what, I think it happened, even if the ALJ said it didn't? Is that what she's gonna do? You said is that how you resolve this tough situation?
in this particular case, Judge, the department's position is the agency took the finding of fact as found by the ALJ. However, he treated this case incorrectly. It wasn't a disciplinary proceeding, it was a renewal.
Let's say, so let me go back to my hypothetical. Let's say in a hypothetical situation that this ALJ, under the preponderance of evidence standard, which you say is the correct standard, found that the physical incident didn't happen. And let's say there wasn't, let's make it simple. Let's say there was not anything on the abuse registry.
If there was anything on the abuse registry,
Yeah,
we wouldn't be talking today.
it's my hypothetical.
I understand.
And I want to know whether if there was an abuse, someone just called the agency and said, this woman has poor moral character because I know she abused her child, and you shouldn't rely on the. You tell me that could never happen without the abuse registry.
That's not part of the screening requirements under 402. In other words, what you're saying, your hypothetical is if somebody says, well, they got bad moral character, well, then the agency will, whatever, we have a licensure process to follow in chapter 402. And here's all the hoops you have to jump through, all the ways you have to get screened. One of them being the abuse registry. And if there's nothing found there under your hypothetical, then there wouldn't be a reason to deny an application for renewal of a license or initial license or whatever it might be, because it's not there.
Okay, then, I'm not gonna fight with you on that. Let's go back to my other hypothetical, and this is not hypothetical, because I can tell you right now that I'm leaning against agreeing with your agency that just incident appearing on abuse registry constitutes ground for not renewing the license. So let's say that the three of us, or 2 out of the 3 of us, reject that legal position.
Okay.
Right? Going back to what I said before, there's a finding by the ALJ, and hypothetically, let's say it was based on preponderance of the evidence.
Well,
What would happen then, and what would be the recourse of the agency?
I don't know the answer to that question, Judge, but if if what you're telling me
But
is
we
that,
need to know the answer to that question, because what if we agree with her that clear and convincing was the right standard?
it's
And
not.
then you lose, so you're
No.
just saying you lose?
Well, clear and convincing isn't the right standard under Davis or Osborne Stern.
Let's say we do, answer my question, you lose, what's your argument then?
If you rule that clear and convincing evidence was appropriate in this case,
Yeah,
then I think we do
you
lose.
lose.
Correct.
Right, because there's if we decide as a matter of law that if the one incident report on the registry is not proper grounds for denying the renewal, and if we agree that clear and convincing evidence is the proper standard, then your agency had rejected a finding of fact that was based on competent and substantial evidence, correct? And you lose.
I don't think the agency rejected any finding of fact in this case. That's my position.
Why would you
However,
lose? You
if,
said you lose.
well, I was trying to get back to where I was trying to get to. If the correct burden was applied in this place, in this particular case, perhaps we wouldn't be here at all. Perhaps there would have been a different, recommendation by the ALJ. I don't know the answer to that question. I mean, at best, a remand for that kind of determination.
You are technically out of time, but since I'm giving Ms. Henn another 5 minutes, if you want to keep going for 5 minutes, be my guest.
I'll just kind of, state this in closing. If you walk through the recommended order, you parse it out with the final order. The recommended order is really, it starts off, the statement of the issue is removal of the license. Then it goes down and it starts talking about this is a disciplinary proceeding. Then it applies the incorrect burden of proof. Those are fundamental mistakes in that document.
Well, I'm sitting here thinking, as a former trial judge, the AHA put the wrong burden of proof, but that seems like it's a stiffer standard than the correct burden, which is a preponderance. So if you over-examined it and you didn't need to go that far, and it could have been just a preponderance, is that harmless error?
On part of the ALJ, is it harmless
Yes,
error, Judge?
correct.
I don't think so. That's why we have different burdens of proof in our justice system. We have preponderance of the evidence, we have clear convincing, and we have beyond a reasonable
Now, is that
doubt.
because the burden was on, is that because, I'm assuming you're assuming that because that's because who had the burden, in other words, the ALJ found that someone did not meet the preponderance of
Well, the ALJ inappropriately placed the burden.
But I'm saying, the reason why it does matter, I'm assuming you would contend, is that because the entity that had the burden, the agency, didn't need to go all the way to clear and convincing. In other words, the ALJ said it didn't happen by if applying it. I'm feeding you a softball question.
Thank you.
I'm on your side on this one. I just wanted to say that.
The ALJ inappropriately placed the ultimate burden on us. Under the statute, in the final analysis of this case, it's the applicant's burden each and every year under 402, 308.
By the way, I didn't mean to be, that was a joke. But my point is, like, if I accept that you're right, that the burden of proof does matter because what the ALJ was actually deciding was that your client didn't meet its burden of proof to prove that the incident happened.
Correct. That's exactly what
Then,
happened.
so if you're correct, if you're correct on that, I still go back to the issue, which is what should happen? Should you lose or should you send it back to a new for another hearing? In other words, do you get to reject it? Is what I'm saying. That's
The agency, you mean, Judge?
Yeah. Does the agency get to reject it and just say, you know what, we're on our own. We're now free to just determine this finding, this factual matter on our own. Is that the way it works?
If in this case, if the agency made a mistake, Judge, which I think based upon the finding of facts, the department's position is it didn't. If the court's position that if the agency made a mistake in this particular case, then I think a remand for applying the correct burden to the facts at hand is important, and putting the burden on the correct party in the first place. It just simply didn't happen.
And do we have authority that in 120.68 to our judicial review? What do we do there?
On your judicial review?
Yeah, what do when we say, how granular can we get with our remand instruction?
Judge, I'm not going to presume to tell you how to do your job.
No, you have a plan of legal options of what you can ask us to do, right? Well, you're not the appellant, I get it, but.
Yeah, but so.
Well, would you have had to cross appeal that issue?
I don't think so, Judge. We weren't asking for, or, you know.
You're not complaining here about the wrong burden of proof and asking, you're not complaining about the wrong burden of proof on the clear and convincing of the ALJ's findings.
Absolutely, it was incorrect.
But to me, it sounds like you're more or less saying that it's irrelevant because the statute prevails and simply because there was a verified abuse record.
Applying the correct burden of proof in every case is always relevant and important.
And I
And if you
hear what
apply-
you're saying, but it sounds to me that the standalone for your argument is that you're just simply relying on the statute, the fact that there was a verified abuse report.
It's based upon the ALJ's finding of facts, Judge. However, if the ALJ would have taken the correct burden of proof and applied it to the correct party in this case, perhaps the outcome would have been different. I don't know. However, that's what should have happened, and that's what didn't happen. The agency's final order was its ability to correct that. Of course, there's always one party disappointed in litigation. I've learned that throughout my career, and that's why we're here today.
But you've got a minute left. Do you want to end on that note, or do you want to go for that extra minute?
No, I just want to thank you all for your time. It's been a
We
pleasure.
want
I've
to thank
enjoyed
you
it.
for your candor. We're sorry for the inconvenience. I gave Ms. Henn the same 5 minutes I'm giving you.
Of
I
course.
want to use it, all or some of it. You don't have to. Totally up to you.
I'll just take 1 minute. In terms of the automatic disqualifiers, the statute does have automatic disqualifiers in there in the level 2 screening. So if you have certain criminal convictions, then you're automatically disqualified, but there's no similar statute that has an automatic disqualifier. You're just supposed to look, at the registry. Then the abuse report did come in, in June. And so she had a right to, it wasn't verified at that time, she had a right to challenge it, which is why it was sent to the department, DOA. And other than that.
Well, let's just go ahead.
So if we reverse based on the reading of the statute as you've argued, but we find that the burden of proof was wrong and should have been a preponderance of the evidence, what are you asking us to do?
I am asking that you affirm the recommended order, to remand for entry of the acceptance of the recommended order. It's what this.
Why?
Why?
But in other words, let me ask, when I say why, I said, well, based on what? If the improper application of an evidentiary standard essentially wipes clean that finding, there's no finding. I mean, there hasn't been a finding on which to, in other words, it eliminates the finding of bad moral character that the department imposed, but it doesn't, there's no alternative finding of good moral character, because the judge made a determination on an underlying factual question on a wrong standard of proof.
Well, I would argue that the secretary, when she entered her final order, if she really believed it was an incorrect standard of proof, at that point, she could have sent it back, but she didn't, she just adopted it. So I think I think it's clear and convincing evidence is the correct standard of proof. Secondly, we'd argue that the department invited that error when they said in their proposed recommended order that this was clear and convincing standard of proof. So they invite the error and then want to go back to redo this after they actually invited it. Now the department says that was a mistake and the attorney wasn't authorized to represent that. But at the same time, my clients are bound by what I represent. So we also believe it's a harmless error because under any standard, the administrative law judge found the trouble team not credible.
Yeah, but as we talked about Judge Valenti, you're kind of saying what Judge Valenti was saying that, or just proposing as a point of discussion, which is that it doesn't matter. But the alternative to that is what I discussed with opposing counsel, which is, doesn't it matter if the party with the burden had to meet a higher standard than the law imposed?
Well, not if the facts show that it wouldn't have mattered under any standard.
No, but, okay, so that's a good question. So we can do that now? We can say, you know what? I think under preponderance of evidence, they didn't meet that either.
Under the
The appellate
harmless,
court can do that?
well, I think the appellate court does in criminal cases, you know, that this court looks at it and says, well, you know, it wouldn't make a difference because the administrative law judge found the fellow completely.
In other words, there's
lacking
competent substantial, we're supposed to determine whether there was competent substantial evidence, which would mean
Support
if
that
there
finding.
was, then the agency didn't have discretion to reject that factual finding. And we can, you're saying as an appellate court, we can say, well, I'm determining that there was a preponderance of evidence, or excuse me, there wasn't a preponderance of evidence. The competent substantial evidence was not even enough to overcome a preponderance of evidence standard. We can make that determination.
No, I'm saying the reverse, is that you can say the administrative law judge, based on what the department said was the standard of proof, is clear and convincing evidence. And if you decide, I disagree that it's preponderance of evidence, did you say, well, it's preponderance of the evidence? And then you can look at what the evidence, the competent substantial evidence that was admitted at trial, at the hearing, and the findings that the administrative law judge made that the child was not credible, and say that it's harmless error if we send it back because the administrative law judge found him not credible.
I don't want to interrupt you, but you've used your 5 and then some, so I'm gonna call a draw on this.
Okay.
You both did a great. You can't do your thing, that's totally acceptable, that's our thing, but 7 days is yours, all right? Use those 7 days wisely.
Thank you, judges.
Have a great
But we
day,
appreciate your time today.
thank you. All right, we're gonna move on to the next case, that's the unknown heir, AKA